So day 5 is now over in Theodore Edgecombe's trial. Spoiler alert, his attorneys still suck. Spoiler alert, they really fucked up again today. Hello again, everybody. Sean Martin. I'm an attorney out of Cleveland, Ohio, and today we're talking about the Day 5 recap in Theodore Edgecombe's trial. The state was still presenting its case in chief when it called up Thomas Ballesteri. He is the landlord for the house Theodore lives in. He lives in the upper floor. Theodore lived in the bottom floor. He testified that he saw Theodore there all the time. In fact, he parked his bike outside. Now, why is that important? Because his bike was found in the basement, and it goes to show once again this allegation that he had a guilty conscience for shooting Jason Clearman. Next up was Detective Alvarado from the Milwaukee Police Department. He covered more of the search for finding any camera footage that was available. I'm not going into this camera stuff again. Next up was Emily Schmidt, the DNA examiner. She explained there wasn't any DNA she could use to reliably determine some of the things that were found. Once again, the DNA is not going to solve or break this case. Then finally came Heather Williams, and she is a firearm and tool mark examiner. Now, this one was interesting because she talked about what she found and what she analyzed. In fact, she analyzed a 9mm bullet, and she describes it very well.
Were you able to come to any conclusions as to that bullet?
I was able to determine that that bullet was a 9mm caliber full metal jacket bullet, and that it had 6 lands and grooves or markings that are left by the rifling or that spiral pattern within the barrel of a firearm, and also had polygonal type rifling.
Now, if you're a person who understands firearms, polygonal rifling or polygonal rifling is not common in every type of semi-automatic firearm out there. In fact, only a couple manufacturers do that. And there's one in particular. I know the answer, and some of you probably do. But let's get to the rest of her testimony.
Now, there is one other thing or one other portion of this in regards to the cartridge casing and the fired bullet I want to talk about. They're both 9mm. Did you determine that they had any characteristics or anything similar to a possible particular brand of firearm?
Yes, based upon the class or basic characteristics that I saw on the fired bullet and fired cartridge case, I was able to determine that it is possible that the fired bullet and fired cartridge case were fired from a 9mm caliber semi-automatic pistol manufactured by Glock.
So she says that the bullet, which came out of Jason's skull, and the casing to her appear to have been fired out of a Glock semi-automatic handgun. A 9mm Glock handgun. Probably like this one. But if you remember from the day before, what was the scandalous item found in Theodore's closet? Pistol magazines. But from what brand?
Let's talk about State's Exhibit number 65. You said 2 items.
Correct.
What were they?
Those were Ruger 9mm magazines.
Now, I'm going to show you what has been marked as State's Exhibit number 71. Does that show the shorter magazine in a certain way?
It does.
And what does that show us?
It shows that magazine, which is loaded with the cartridges that we just had up here in front of me on the table.
Okay.
That's right, Ruger. Ruger is not Glock. Now, why is this important? Because they tried to claim, oh, well, this is a 9mm ammunition. We found it in a 9mm pistol magazine. We found it in his home. This was probably what was used. A Ruger handgun. Yet now they're claiming it was most likely a Glock handgun. That's a big discrepancy. And honestly, if somebody had been paying attention, you may have gotten some evidence suppressed or kicked out, which would have limited either just the toolmark examiner testifying or the detective finding the weapon testifying or the magazines testifying. Instead, it all came in. There's conflicting evidence, and they didn't bring it up. Now, why am I pointing this out? Is this going to be the ticket that Theodore can get home on? No. But it shows the police, and the prosecution in particular, are being sloppy. They didn't even care to check. These are fine little details, but that's a big detail. The firearm they claim was used is different than other evidence they found they're trying to use to infer guilt on their client, and the defense attorneys are sitting there with their thumbs up their asses. Why? Because they're not really able to handle a self-defense case. Like I said, I think it helps in a self-defense case. You understand weapons. You understand some basic principles behind them. All those guys know are, gun shoot bullet. That's all those two know. They didn't bother to catch that. They didn't bother to check. So now all this evidence is accumulating, and it's piling on Theodore. You know, like I said, I'm not expecting them to hit a home run every time, but Jesus Christ, it's like they didn't even bother reading. Oh, they found a gun, they found a magazine, whatever. First up was Officer Nebraska, once again going into searching for cameras. I'm not getting into that nonsense again. It's a dry hole. It's not going to help the defense at all. Next up was Officer Tivnan, and this was about interviewing a potential witness who claims to have heard. I don't really know exactly what it was going to get to, but it's something that the officer himself deemed irrelevant. This is a spot where the defense really fucked up, because they got caught lying. And it's not necessarily that they were lying, but I understand they might have been talking in parlance. But you can see, if you're from the jury, this doesn't look credible. This looks very dishonest.
It's also important to keep your body-worn camera on at all times when investigating a potential homicide, correct?
There's an exception in our SOP that we can turn our cameras off for particular purposes.
Okay. And those particular purposes would include if you're concluded your role in that investigation, correct?
That is one of them, yes.
Objection, Your Honor, relevance is to this line.
At this time, I would like to continue playing the conclusion of the video, please.
Objection, Your Honor, is to the relevance.
How's it relevant?
Because Officer Tivnan cuts his body camera off immediately after these remarks were made by the fuck that we got enough. His body
Objection,
worn
that's
camera
not
goes
true.
off. The video will prove it, if we can play it.
No, you can't right now.
Actually, after that assertion, let him play it. It's not what happens. That's fine. Let him play it.
Fine, I'll say withdraw their objection.
You could go back about 5 seconds so we can get a full.
No, play from this portion.
Play it from where it is right now.
Officer Tivnan also identified the type of bike Theodore used, and it's actually kind of impressive. He could tell from a shady and shadowy image from a traffic cam what type of bike it was. That was actually kind of neat. Next up was Officer Hernandez, and once again, just like Officer Nebraska and half of the people called in this trial, was about cameras. Yeah, they went to a house, they found it had a Ring doorbell. Apparently this doorbell was set up to only record and transmit live, so there was nothing at the point by the time they came to look for it. Once again, it's a dry hole, and I don't know why the defense keeps going down it. Next up was Stephanie Trotter. She was a woman who called 911. She also did observe Mrs. Clearman trying to, as she claims, trying to get into his front pockets. It does become clear on cross-examination she couldn't do anything because he was laying face down, so she didn't put anything in and she wasn't able to take anything out, which is really hurting the defense. That was one of the big things I think they wanted to get at, that Evangelina Clearman was fucking around in the pockets, but it became clear through cross-examination that never happened. The last person to testify today was Ricky Burhams. He is a retired Milwaukee police officer and detective who was brought in by the defense to criticize and find holes and failures in the police department's case and investigation. This was really rough. It was bad. And the prosecution sums up his arguments very quickly and very succinctly.
And sir, I want to make sure I have this correct here. You're testifying as to what you're saying is an incomplete investigation, based solely on what one party gave you, without asking for any additional information.
That's correct.
Never wanted to know if there was maybe a report they failed to give you, right?
No.
Never wanted to know if maybe they were holding something back from you that might affect whether or not you thought it was a good investigation?
No.
Never entered your mind?
No.
Not once?
No.
You know that there's tons of body cam, they give you one, never occurs to you to think, maybe I should watch the rest of it?
No.
You know there's multiple 911 calls, never occurs to you to think, man, maybe just for purposes of being thorough, like I'm accusing other people of not, I should listen to everything.
Yes or no?
Yeah, does it occur to
No.
you?
No.
Okay.
you can't have really crappier experts than that. This is, like I said before, this is Bush League. These guys, if they're defense attorneys, I don't know what the hell they've tried before, because this is not how you try a case. I wouldn't even try a disorderly conduct, where you, any one of you, gets drunk and passes out on the sidewalk in front of a bar. This would have been pathetic for that type of an offense. I don't know what the hell they're thinking at this point. There was also discussion of Dr. John Black, who you may remember from the Kyle Rittenhouse trial. He will be testifying tomorrow, and he's going to be testifying to a number of things, but as you can see, the court had some problems with the way the defense produced evidence for the state. Now, why is that important? Well, in an adversarial system, you provide evidence to each other in advance. Anything the state wishes to use in their prosecution that they intend to show at trial, they have to show. Likewise, the defense has to do the same thing. Any evidence it intends to show at trial. Now, there is an exception for impeachment evidence, but that's another topic for another day. Generally speaking, any witnesses you plan to call as a defense attorney, you have to provide notice and the evidence they're going to testify to.
Created very short clips.
So hang on. You want to introduce evidence that you didn't have till Saturday, that you didn't give to the state, that the courts had no notice of, that was not listed as part of the motion, that was not listed at any point in time as to what this witness is going to...
In this case, that didn't happen until Saturday, and that's very, very late. That should have been done before trial, but it didn't happen. And the judge very succinctly pointed out why he was not going to allow it. And once again, the judge had to point out this is not the Kyle Rittenhouse trial to defense counsel.
And the other issue is about video focus and how that differs from first-person perspectives, and what the eye can focus on in a moment is different from what video shows. And these are things that he testified to previously in a case that the court knows well about. So,
Mr. Ahmad, don't make me say again that this is not the Rittenhouse case, okay? It's not. And I don't care what he testified about in that case. I do not care. He will testify under the law and the facts in this case. And you and your co-counsel had multiple motions, a dozen at least, that were filed, all of which were ruled on.
You know, honestly, I really was hoping, against all hope, that once they got their chance to present their case with their witnesses, they would be good to go. They would be able to make some hay while the sun is shining. And they can't. They've got nothing. This case is bullshit. I mean, this is just straight up awful. I can't even begin to fathom what they promised Theodore, and I can only hope to God he didn't pay them that much, because these guys aren't worth much. I mean, this is just bad. And the sad thing is, this is not even ineffective assistance of counsel. So when Theodore gets convicted, which he very likely will at this point, absent him nailing it on his testimony tomorrow, he'll get convicted, and on his appeal, they will not be able to argue ineffective assistance of counsel. Why? Because while these guys sucked, it wasn't ineffective. Well, that's it for today, guys. Tune in tomorrow. We actually might be able to live stream some of it in the morning. Either way, it sounds like the case will be wrapped up by lunchtime. It sounds like closing arguments will have been done by that point, and the jury's going to have it. So, guys, I will see you tomorrow, and remember, until then, just because you did it doesn't mean you're guilty.